So we often hear about tax avoidance versus tax evasion, right? And I think most of us, we basically get that one is legal, maybe a bit cheeky, but legal. And the other, that's a criminal offense. Serious stuff.
Absolutely. And people know individuals can be liable for evasion. Makes sense.
Yeah. And even, say, the accountant helping them hide income, they can get charged too. We get that.
Right. Aiding and abetting, that's pretty established.
But here's the thing that always felt a bit strange, maybe. For a long time, there was this, loophole, I suppose. The person doing the dodgy accounting could be in trouble, but their employer, the firm, the company, the partnership, they were often sort of off the hook.
Yeah, largely insulated, even if the organization, benefited massively from it or maybe even encouraged it behind the scenes. Proving the company itself was criminally liable. Very difficult.
Okay.
And that right there is exactly what the UK's Criminal Finances Act 2017, the CFA, aimed to fix.
Yeah.
Our deep dive today is really digging into how this act, changed the game. It brought in these completely new corporate offenses. Basically, if you fail to prevent someone facilitating tax evasion for you, your company could be liable.
Fail to prevent. Okay, that sounds significant. You said it fundamentally changed the game. That's a big statement. What's the biggest immediate difference a company would feel now compared to before 2017?
I'd say the biggest shift is moving from being reactive to being proactive. Before, proving corporate criminal liability was frankly a nightmare. You often needed to show a directing mind and will was involved, someone really senior.
Right, hard to pin down.
Very. Now, the law effectively says, look, someone associated with you facilitated tax evasion and you didn't have reasonable measures to stop it, then you, the company, are potentially liable.
Wow.
It forces every single business, big or small, to actually think about and manage the risk of tax evasion happening via their operations, not just by them directly. And that includes everyone working for them, not just employees.
Okay, that's huge. So let's back up just a tiny bit to make sure we're all crystal clear. That basic difference, avoidance versus evasion, can you just quickly nail that down for us again? It feels key here.
Absolutely. Good point. So tax avoidance is using the legal framework, the rules, reliefs, exemptions to minimize your tax bill. It's within the law.
Legal.
That's
but
right.
Maybe pushes the boundaries sometimes.
Exactly. Tax evasion, though, is totally different. It involves dishonesty, deliberately misleading HMRC, concealing income, falsifying documents, outright lying.
Right. That's criminal, full stop.
Full stop. It's things like cheating the public revenue, that's a common law offense, or specific statutory offenses. It's always illegal.
Got it.
Now, as you said, before the CFA, if an accountant, for instance, knowingly helped a client evade tax paying, criminally evade self, they could be prosecuted, aiding and abetting.
Yeah.
But their firm, the partnership or company they worked for, it was surprisingly tough to hold the organization criminally responsible, even if the firm benefited financially or maybe had a culture that, turned a blind eye.
Right. It created this sort of shield for the company itself.
Pretty much. A perception and often a reality of corporate immunity, even when their people were facilitating serious financial crime.
And this is where the CFA 2017 steps in and just rips up that old playbook.
It really does. It introduces two main corporate offenses. Section 45 covers the failure to prevent the facilitation of UK tax evasion.
Okay.
And Section 46 covers the failure to prevent the facilitation of foreign tax evasion offenses. So it's got global reach, too.
Foreign tax evasion, too. Interesting.
Yeah. The core idea for both is, if a relevant body, we'll define that in a sec, has an associated person who commits a tax evasion facilitation offense, then the relevant body itself commits an offense.
Unless
there must be a way out.
Unless, crucially, they can show they had reasonable prevention procedures in place. That's the key defense.
Okay, let's break those terms down. Relevant body sounds quite formal. Who does it actually cover? How wide is this net? It's deliberately very wide. Section 44, subsection 2 defines it as any corporation or partnership, whether formed in the UK or elsewhere.
Any. So not just UK companies.
Nope. Any corporation, any partnership, anywhere in the world, if there's a UK link to the facilitation or the evasion itself, depending on which offense we're talking about, it covers basically any incorporated entity and any partnership structure.
Okay, that's pretty encompassing. And then the next bit, the associated person. Who falls into that category? Is it just direct employees on the payroll?
This is where it gets really broad and where companies need to pay close attention. It's much wider than just employees.
Okay.
Section 44, subsection 4 lists them. It includes, yes, an employee acting as an employee.
Standard.
An agent acting as an agent.
Makes sense.
But then there's the big one. Any other person who performs services for or on behalf of that relevant body and acts in the capacity of a person performing such services.
Okay, unpack that. Any other person performing services for or on behalf of?
Exactly. Think about who that includes. Independent contractors, consultants, subcontractors further down the chain, possibly even joint venture partners in some circumstances. Anyone providing a service for your company.
So if a contractor you hire facilitates tax evasion while doing work for your company could be liable for failing to prevent it.
Potentially, yes. That's the whole point. The company's reach of responsibility extends way beyond its direct employees.
That's a massive expansion of risk, isn't it?
It is, and it's important to understand why the company is liable. The individual, the contractor, the employee, whoever still has to commit a criminal act of tax evasion facilitation under the existing law. That's the trigger.
Right, the person still did the crime.
Yes. The company isn't liable because the individual's crime is magically transferred or imputed onto the company's record. No. The company is liable for its own distinct failure.
It's failure to stop it from happening.
Precisely. It's failure to exercise the necessary degree of supervision and control, as the guidance puts it. It's a separate offense of omission, of not having the right safeguards.
So just to be really clear then, the company isn't being done for actively helping or planning the evasion. It's because they didn't have good enough systems to stop someone acting for them, from doing the dodgy stuff.
You've got it exactly right. It's not about the company's positive action in the evasion scheme. It's about their negative failure, the failure to have reasonable prevention procedures, which naturally leads to the big question.
How do you defend against it? How does a company protect itself?
Well, the Act builds the defense right in. Section 45, subsection 2, a relevant body has a full defense if it can prove.
Prove. So the burden is on them.
Yes, the burden shifts to the company. They need to prove that when the facilitation offense happened, they either had such prevention procedures as it was reasonable in all the circumstances to expect it to have in place.
Okay, reasonable procedures.
Or the alternative defense, which is probably rarer, is proving that it was not reasonable in all the circumstances to expect the relevant body to have any prevention procedures in place. Maybe a dormant company, perhaps, but for most active businesses, the first defense is the key.
That word reasonable, it crops up everywhere in law, doesn't it? What does it actually mean here? Are we talking about companies needing Fort Knox level security around everything? Is it a huge burden?
That's a really common concern, but the guidance makes it clear the intention isn't to be ridiculously burdensome. Reasonable means proportionate.
Proportionate to what?
Proportionate to the risks the organization faces, the size of the company, the complexity, the sector it operates in, where it operates, the types of third parties it uses. All that context matters.
So what's reasonable for a giant multinational bank will be very different from a small local consultancy.
Exactly. And the Act actually required the government, specifically the chancellor, to publish official guidance on what these procedures might look like. Section 47.
And that guidance exists.
Oh, yes. HMRC published detailed guidance. It outlines principles like risk assessment, proportionality, top-level commitment, due diligence, communication, training, monitoring, and review. And it specifically allows for industry bodies to develop their own sector-specific guidance, which HMRC might endorse. So it's meant to be tailored.
Okay, that makes it sound a bit more manageable. Proportionality is key. Now, quick technical point. You mentioned earlier partnerships. They're included as relevant bodies, but are there any special rules for how they're actually prosecuted, since they aren't always legal entities in the same way as corporations?
Good question. Yes, the offense applies equally to partnerships, but Section 50 of the Act addresses the procedural side for ordinary partnerships, so not LLPs, which are bodies corporate anyway.
Right.
For ordinary partnerships, proceedings must be brought in the name of the partnership itself, not against the individual partners personally for this specific offense.
Oh, okay. So Smith and Jones gets charged.
Yeah.
Not Mr. Smith and Mr. Jones individually.
Precisely. And any fine imposed is payable out of the partnership's assets.
Not their personal assets.
Not directly from personal assets via the court order for the fine itself, though obviously partners' assets are ultimately linked to the partnership's solvency. But the fine targets the partnership funds first. Section 50 effectively says that for these purposes, an ordinary partnership is treated as if it were a body corporate.
That's quite neat, actually. It closes off another potential loophole, doesn't it? Making sure the structure doesn't prevent accountability.
Absolutely. It shows the law trying to adapt to different business structures to ensure the core principle applies across the board.
Okay, so let's pull all this together. This deep dive really paints a picture of, well, a pretty fundamental shift, like you said at the start. It's moved corporate accountability for tax evasion facilitation away from just punishing the individual who did it, towards making the organization itself directly responsible for essentially not preventing it.
It really has. And if you look at the bigger picture, this fits into a much broader trend we're seeing in corporate responsibility generally, doesn't it?
How so?
Well, think about anti-bribery laws, modern slavery reporting, ESG requirements. There's this increasing expectation, legally and socially, that organizations must be proactive. They need to actively build systems and cultures to prevent wrongdoing by anyone acting on their behalf.
Yeah, it's not enough just to react when something goes wrong anymore.
Exactly. The CFA is a prime example of that shift. It's pushing for a proactive compliance culture, making prevention, not just reaction, the standard.
So a final thought maybe for everyone listening. As you think about this, consider how this focus on preventing facilitation by associated persons might ripple out. It's obvious for financial services, maybe law firms.
Sure.
But what about, say, construction, tech, retail, any sector that uses contractors, agents, intermediaries? You need to ask what kinds of prevention procedures might be reasonable in your specific context. Even if tax evasion feels distant, this law makes preventing its facilitation your business.
A very important question for businesses everywhere to consider.